This is case D 489676, Wells versus Mark Van. Counsel, appearance for the record.
Good morning, Your Honor. John Keller, bar number 6012, on behalf of Ms. Wells, Your Honor, who's present.
Okay.
Jason Stoffel, bar number 8898, on behalf of Michael Mark Van, defendant, present, unbundled capacity.
Okay.
Your Honor, was one agreement that was reached. As far as the extracurricular expenses, that's been resolved.
Okay.
So, other than that.
You mean what was due got paid, or how was it resolved?
He's agreed, from what I understand, to pay the extracurricular expenses, and he's paid what was past due. So he's going to continue to pay the extracurricular expenses, and he paid what was past due.
Okay. Because I am going to modify that provision in one way so we don't have any issues in the future. Let me kind of jump to a couple things. It was actually in the pleadings and requested by counsel, and I am going to go ahead and adopt. That would be the... I don't know why we went from 0 to 60. It was a case that was filed. It ended up as uncontested. There was no action on it for a couple of years, and then it seems like we went from 0 to 60. And maybe I'll ask a couple questions and see why we got from such a dormant case to what seems to be a very high conflict case. And I say that in that we got basically kitchen sink arguments from both sides alleging everything under the sun. But there was a request that the parties attend the UNLV Cooperative Parenting course. I'll go ahead and adopt that request. I do believe that given the current pleadings that the parties would need that service there to complete that within the next 6 months. I'm also going to order that they enroll and use Our Family Wizard to cooperate, and the sub-program for the exchange of unreimbursed medical expenses, and now we also have these extracurricular stuff. But I also went back and I looked through the parenting agreement that was adopted by, I think Judge Ochoa had this case before. I am going to modify that the provision regarding extracurriculars, the way it was drafted by FMC, it must be upon mutual agreement by the parties. It now must be by mutual agreement in writing by the parties for there to be reimbursement. Okay, so if you guys agree in writing, and I consider Our Family Wizard electronic writing, so if you agree by Our Family Wizard that you're going to be responsible for this particular extracurricular activity, then you're going to be on the hook for it. And if you say I'm not going to be ever in the future, then you never will be liable for any expenses in the future, and it really won't be an issue. It's one of those cases where I don't know what their incomes were back in the day, because I also went back and there was no financial disclosure forms filed because it was an uncontested type of matter. So it's not anything I can really look back and say, oh, this is what they were claiming a couple years ago. Oh, yes, there has been a 20% change of circumstance. Additionally, Mr. Kelleher, you're asking for an order to show cause, and if you truly want to go forward with that, if you want to submit it, I'll sign it, and we'll set it both for those purposes. But I don't have any financial information, which I would have to have from the date they entered this order to today to see if there had been the 20% change of circumstance before I could even consider. Because if there hasn't, then it would be another year before they'd be up for the mandatory review.
Well, respectfully, Your Honor, I could certainly do that, but what I would submit to the court, and I don't think it's disputed, is that at the time that this decree was done, he was working a series of different jobs and didn't really have income that could be in any way ascertained. And now it is all ascertained and documented, and in his FDF it shows $5,000, and my client's making $27.66.
Oh, I can absolutely see what they're making right now. Actually, he lists 5, but he's actually one that overstated, because we went down and my law clerk, whenever they attach proofs, he breaks it down by the day and divides it. It actually comes up as $35.59. Your client's comes up as $17.03. There's a difference in income. There absolutely is. I just don't know what it was, and I know what your allegations are. But I guess it'd have to be tax return. I guess. I mean, you have to get the tax return from what he claimed in 2014 as compared to what he's making now.
The only reason I say that, Your Honor, just as a suggestion, and again, the court, is rather than the expense, maybe you could just ask him. There's also another ground, Your Honor, is that in terms of the schedule, and you could consider this, but whether you give it any weight or not, it would be up to you, is that the schedule, Your Honor, my client got a lot more time than what was contemplated in that schedule. We gave you a list of all the different additional times. So under the statute, Your Honor, you could look at that and adjust child support accordingly. So there's really two grounds. One would be, that you have a 20% change, and the other one would be that there was a change in the actual visitation schedule. They have not been following what's in the agreement, which I know is not unusual, but she's had a lot more time. We're not asking for a change of custody, but that would trigger, Your Honor, the court's ability to look at the issue of child support under a kind of a look-back provision within the 3 years, under just a regular change. But you probably could ask him. I don't necessarily think that he would deny that he's making more money now than what he was 2 years ago. But
I don't know if they're going to admit 20%.
I guess the other thing is figure out what her income is. She listed that she works on the Strip as a waitress or at a restaurant in Margaritaville, and so you have tips. She lists a big old goose egg.
I get that. That's what I'm saying.
Right. What I proposed to him, I said, look,
she didn't list goose eggs, Your Honor. She listed.
Listen, these are not things. I will set up for an hour evidentiary hearing. We'll deal with your contempt. We'll deal with your. And again, they'll learn that if they want to come to court, it'll end up in a lot of attorney's fees and costs. And if they're both in contempt, if she's in contempt on any little thing, then under Lamb versus Lamb, then she's not eligible for contempt.
All right, I'll issue it, and we'll just set up for that. That's fine.
One thing, Your Honor, is you can't issue. You don't have jurisdiction on contempt. The reason why is because there's no AWOD affidavit attached to their motion, so it's not procedurally before the court. If you look, you have to put in there facts constituting contempt.
That may be why my
observation. So that's one of the things that I don't know what was done or why that was done. So that request for an order to show cause must be denied under AWOD. If you look on page 12 of their motion that was filed, you can't do. That's the only time in family law that I know that you can't do a general. I read it, understand it, I'm good. Reincorporate.
I understand that. Listen, then I will afford them the ability to go back and you are correct.
Right. But if they want to go ahead and do that, but I'm not sure what they're asking for.
I don't know either.
For contempt, so
and I will another provision that I am going to modify, which the court has the authority to, and this comes from. This is clearly turned into, again, I don't know why. I mean, is there a new significant other? What's happened in the last, that all of a sudden this went from 0 to 60? New significant other?
There was, I think, at one point, not anymore now.
Well, that's...
There was at one point, but that's not the reason for this. The reason for
yeah,
this
well, usually it is, because you guys have stayed out of court for the last couple of years, then all of a sudden...
Well, age of the child, too, now that she's,
Well, I feel that this was brought on because I got the new job, I was making more money, and she felt that she was entitled to it. It was all spawned shortly after I got this new job in March.
So what I was telling him is the easiest way to tackle it is May 1st, exchange your tax returns, then June 2017, you're eligible anyway for a 3-year review, and then we'll know once we see her.
She has every right. I mean, if she wants to go forward with it, then go forward with it. But again, before I lose my train of thought, I am going to modify, and again, this comes from Margaret Pickard, Claudia Schwartz, all the people who deal in the high conflict cases indicate that there should not, in high conflict cases, be any right of first refusal clauses. But if you are going to do it, at a minimum, it should be 12 hours. So that 3 hours will now be 12 hours. And if, in fact, we have a problem with 12 hours, then we'll just simply strike it completely. But they only cause problems in high conflict cases. So, Mr. Kelleher, you're going to have to, I guess, Mr. Stoffel's requiring you to supplement your motion to include the specific brief. My law clerk will then review it against your proposed order to show cause. We'll then sign it. But again, at a minimum, is he going to admit the 20% change or not? I mean, let's just be candid.
I think that he's about there. I'm not sure it's exactly
That's fine.
$1.
If you don't want, well,
I don't know what he's making in 2014 to now. I mean,
I don't either.
So that's what I'm
And
saying.
you're his attorney, so
We don't know hers as well, though. So that's it cuts both ways. They have joint physical.
Can you just set it? Can you just set that for the hour, and then we'll provide her with tax returns. We'll come in.
Sure.
And
Do
approve
you
it.
guys want a period of discovery where you do that, where you ask for stuff or not?
Your Honor, we leave it to you. And what are you going to ask for? It's like, we'll give you the tax returns. We'll send a subpoena to his employer. So I guess you could set it for 60 days with look at Ramchodi going backwards from the date of our filing. And in the meantime, I'll go ahead and make it really detailed as to exactly what we're asking for in order to show cause.
Okay.
But just as a heads up, we've attached it all. It's these demeaning and derogatory and four-letter words that he's sending to my client as emails that he's done consistently until now we've come into court and you said that we're going to at least try and have some law and order in the case. But just so that's the preview, that's what it's going to be.
There was some provision about that in there.
Yeah, oh no, it's in there.
Right.
So I'll map it all out.
That's
and
fine.
We've already given her text messages and emails showing what he calls her. So we'll do it. We have no problem with it, Your Honor.
That's fine.
But if we could do the child support.
We'll do both of them at the same time. Again, this is stuff that's going to end up being more legal argument. We'll take limited contempt issues is the court's inquiry. So we usually, because it's my inquiry, we just cut right to the chase. I'll usually ask questions directly of the parties once I'm guessing you'll probably file something the week before. If not, we'll just go right off the actual order to show cause. And then whatever documents you submit as far as income, I'm guessing it's tax return.
Yeah,
let's be candid with ourselves. I mean, it's one of those things where if there's contempt, if there's been a change of custody, and Mr. Kelleher has to put on a trial for it, I mean, something you might consider.
There's no change of custody request, but the other thing also is if you look at the case law in these cases, that when you do pre-decree stuff, this is something that they're including pre-decree text messages.
No, then I.
Oh, they're not.
Yes, they are, Your Honor.
Again, that's for them to substantiate. They're going to have to do that.
I understand, but I'm just saying that that's what's in there. So I think that instead of supplementing the pleadings, they need a new pleading, a new motion, because I'm telling you that I read what I read in there. They're including pre-decree text messages.
Well, whatever came before the custody order. And again, let's all be candid. The last order, it would have to predate
June 2014, I think is what it was.
At the post date that date.
June. I show the final actually that incorporated all of it was July 17th of 2014. So not really a big difference, but.
Well, yeah, I'm just saying, Rooney still has to be applied in these cases. So they're alleging contempt. I don't think you can supplement a pleading to say, now we've fixed a defective pleading. You can't fix a defective pleading. You have to do a new pleading. So it'd be a new motion.
No, I can allow them to supplement. I can absolutely allow them to supplement for judicial economy. I'm not going to make them refile a whole new motion.
Right. Well, then I have to be able to read the text messages because I can't read half what they submitted. So how am I on actual notice of what is being alleged with the dates? Because
that's different. We've now opened up discovery for at least the next 30 days pursuant to 16.201. So if you want to ask for clearer copies or get clearer copies, I mean, it's their burden of proof. You can agree to that, right? On both issues.
I understand.
Okay.
But what are they alleged? It's contempt, and then what? The child support is what?
Child support.
Okay.
And you have every right to go and try to find out what she's actually earning as far as tips and stuff like that.
At least can we ask for a new FDF on her end? Because if you ask her.
Ask her what?
Ask her to file a new FDF. She doesn't list any tips.
Listen. You can do whatever discovery you need to do. They filed what they filed. They both actually attached their actual paycheck stubs.
Right, but she gets tips and she doesn't list tips. That's the problem.
That's the kind of stuff apparently you're going to have to do a deposition. Again, that's what this mushrooms into. Do a deposition. Do the interrogatories. Take coworkers. That's the kind of stuff that occurs.
Not hiding the ball is her income equals her expenses, end of story. And that's the way it's going to have to be, because if she's making expenses paid, unless there's a sugar daddy or I don't know, it is what it is.
Listen, let's not throw around derogatory terms of sugar daddy. I mean, if she has people contributing in her household, that's absolutely something I take into consideration. The stuff, but let's not. My next, in that time period, give me 1 second.
Just so you know, or just to resolve the issue so I don't get some nonsense, on page 2 of 8 of her FDF, it says 3 times a week, the amount of $72, 12-month average, $864 in tips. And we supplied her pay stubs, and I'll go ahead and I'll supply her tax returns. We'll do it. So I get it. Thanks, Your Honor.
Listen, it looks like in that time frame, unless you want to go after the first of the year, would be December 21st from 9 to 10.
That's fine.
But I will put it after the first of the year if you don't want to do it during the holidays.
December 21st is fine, we're 9 to 10.
Let me see the date you're on. I want to double check that. And I'm going to bundle through today, but I mean, he'll probably need me for that. I just want to let you know that if I'm available the 21st, that's that Wednesday, the 21st?
It's a Wednesday.
Yeah, I'm open. I mean, I'm available, so that if that works for him, he'll probably need me, so that's fine. 9 to 10, you said that day?
It is. If you guys are here like at if everybody's here at 8:45, we'll start even a little bit earlier. But officially be here by 9. I'm surprised how many people stroll in for an hour hearing at like 9:20, and we're starting at 9 a.m.
Thank
All
you,
right?
Your Honor. Thank
See you on that day.
As far as anything else, I mean, it's kind of status quo because he had a question regarding the drop-off, the pick-up, drop-off, exchanging the time. Certainly they can do the family wizard thing to do the exchanges. That was causing some of the conflict, I think, in this case. But if you don't want to make a ruling on that issue, I guess that'll be trailed till December if there's any other small housekeeping things. But before we walked in today, I just want to make a record. He was agreeing to both of these anyway, the family wizard as well as the cooperative protocol. It's a lot of help. So we'll see what's what, and we can vacate this.
As far as, and they're not asking for a change of custody, even though she's alleging she has more time. But as far as the actual timeshare, do they want her to go back?
No, Your Honor, we're
okay,
fine
that's
with
fine.
it, and they have a pick-up and drop-off order in the hours, so we're good. Thank you, Your Honor.
medical expenses, that's something that wasn't addressed today. We want to defer that he was alleging that she owes her.
Listen, let me tell you where that would come in. You did not ask for contempt, but it would be a defense if it comes up and you can prove that she didn't. Then she would technically be in contempt, and it would be a defense to her allegation for contempt in Lamb versus Lamb, because you can't come to court asking for relief if you stand in an attitude of contempt yourself, if that makes sense.
Okay, thank you, Your Honor.
All right, we'll see you in December.
All right, you draft that countersign order?
That's fine, Your Honor.
Next.